I'm going to try to keep my talk to 15 or 20 minutes. And I have my friend Z May, who's a web developer and tech consultant, and he'll be trying to keep his remarks to 5 or 10 minutes, and then we'll have questions. I have to realize my limitations. For me to talk, excuse me, could you put the house lights back up and dim those lights, please? Thank you. Trying to talk about technology here would be kind of like an RIAA lawyer trying to talk about law. And I would just make a fool of myself, so I'm not going to really try to do that. I'll try to confine myself to the general subject and to what I know about. One thing I know about is who I am and how I got into this mess. I'll tell you a little bit about that because we don't usually get to talk about that, which is I'm a commercial litigation lawyer who worked in entertainment and communications, and the Electronic Frontier Foundation, who are good people, had brought to my attention about these cases, and I tried to help a couple of these folks. I thought, well, I'm a litigator, I'm a copyright lawyer, and I hate bullies. And I know this is a lot of extortion, it's not really law, and let me see if I can help some of these people. The first few people didn't have any guts to fight it or the wherewithal. And then I had a client that wanted to fight back. And when I did that, I realized the RIA had this strategic advantage. They knew anything about what's going on across the country because they had one law firm handling everything. And I knew nothing. I didn't know what was going on in other cases or if there were any other cases. So I figured, why don't I throw up a blog, or a place where we could collect litigation information, and maybe it'll help to neutralize one of those strategic advantages. And by setting up the blog, Recording Industry versus the People, that wound up sort of putting me into the front line of this war. So that's how I got into this case. I didn't come to it with a love or appreciation of the need for file sharing or with some vision about the future of the internet. I'm just an ordinary litigation lawyer who hates bullies. Now, I want to mention briefly the great economic imbalance in every single case that's brought, because it permeates everything, which is there's no case in which it's not a tremendous economic imbalance. Usually the people that are being sued are middle class or poor people who don't have the resources to fight a federal court litigation. In some cases, they're people who have money, but even if you're a very wealthy person, you didn't get that way by taking a claim that you could settle for $4,000 or $5,000 and spending $200,000 in legal fees that you might or might not be able to get part of that back. So now it's not enough that this is a gigantic corporation, that these are gigantic corporations, any one of which would be a tremendous mismatch against the middle class and poor people that are being sued. But they have to join forces. These four multinational corporations have to join forces and, in my opinion, collusively litigate their claims together, settle them together. You can't make a settlement with one of them without making a settlement with all of them. And they have some guy who's the enforcer who goes to settlement conferences and stuff, and I guess he's there to make sure every company toes the line. Now, I want to briefly talk about the technology, and I put technology in quotes because it could be the lack of technology that we're talking about. The way these cases start, people assume, less knowledgeable people assume that it's got to do with downloading. Every judge assumes these are downloading cases. But as many of you know, this has nothing to do with download. They don't know anything about downloading. All they have is they have this investigator, Media Sentry, who goes on a network that either uses the Nutella protocol or the fast track protocol. And he pretends to be a member of a network like Kazaa, and then he sees a a shared files folder, which he works on the assumption that these are all folders these are all files, they're all song files, and that all he knows is their names. And and many of them could be the same corrupt files that Media Century itself sent out. But in any event, they look at that, they make a note of whatever dynamic IP address comes through in the data packet, and that's it. That's the investigation. They download a sample of usually 6 to 9 songs, allegedly play them, but it turns out that they really don't play them to verify that they're song files, supposedly. And then they turn this over to the RIAA. The RIAA then goes and serves a subpoena on the ISP, says who paid for the internet access account that accessed that IP address at that date and time. And you might think that would be like the place to begin an investigation when they get that information. But that's where they end their investigation, and then they sue whoever the hapless person is who paid for that IP access account, the internet access account. So if someone was coasting off someone else's wireless signal, the person whose wireless signal was coasted on is the defendant in the lawsuit. And that's it. That's their so-called technology. And I have my blog post with materials. I didn't want to bore you with a PowerPoint presentation or anything, and I'm not that organized that I would know how to do that anyhow. But the materials are up there, and like I have a string of documents where sometimes they say Media Century was an investigator. Sometimes they say it wasn't an investigator. Sometimes they say it's an expert. Sometimes they say it's not an expert. They will say anything in order to try to avoid whatever the consequences are to whatever position they've taken. These people have no respect for the truth. So I don't know what Media Century is, and they won't say we don't know what it is. I don't know if it's technological or if it's not technological. Now, this technology winds up affecting the substantive law because they have no evidence of any actual person actually infringing anybody's copyright. They try to stretch the law. The two big areas in which this is affecting the copyright law is the making available and the secondary liability. Making available is this theory that they came up with, which has no place in the Copyright Act, which says that if you have something available, that you make something available to somebody that could lead to a copyright infringement, that's a violation of the distribution right. They have no basis for this. They've been making the argument for years. I challenged it in 2005, and finally we have a string of decisions starting early this year, which have rejected the RIAA's theory, none of them at an appellate level. And the most famous case, which was the one that resulted in that crazy $222,000 verdict in Minnesota against the Native American woman for 24 songs, the judge now realizes that he was misled by the RIAA lawyers, and he was let down by the defendant's lawyer, who didn't brief the law properly, and he's now saying that he's probably going to be setting aside the verdict and having a new trial. So this is starting to be eroded, but it's still not at a appellate level. Secondary liability in copyright law is pretty clear because we have a recent Supreme Court pronouncement, MGM versus Grokster. Most people think MGM versus Grokster was like this terrible decision, against file sharing and stuff like that. But I really don't read it that way, because as a veteran of copyright law, it actually sets the bar higher than I've ever seen it set before for secondary liability. It says that you cannot be liable for someone else's copyright infringement under secondary liability theory unless you intentionally induced or encouraged them. Now, most of these cases in most of the cases, the defendant is completely innocent. In some of the cases, it was the defendant's internet access account that was used for file sharing, but the defendant didn't know anything about it. Sometimes it was, in some of the cases, it could have been some stranger coasting off their signal, but in some cases, it could have been a child, a friend of one of their children. There's a lot of cases where, a niece or nephew, all kinds of situations like that occur where the defendant is being sued because of something they didn't even know their computer could do, because someone else might have done it. So the RIAA broached that subject. They've stayed away from it, but in settlement, they're constantly, and in talks to judges, they're constantly saying that you're liable and you're responsible for what happens on your internet access account, which is contrary to what MGM versus Grokster says. So in Capital versus Foster in Oklahoma, when the judge slammed them with $68,000 in attorney's fees, one of the things he pointed to is why he was assessing the attorney's fees was because they made this marginal accusation that the mother should be responsible for the daughter's infringement. And he just said there's no basis for that. Now, so you see the technology gives, the lack of technology, the lack of evidence gives rise to these substantive copyright law claims that they're making. But then the circle goes back because if these legal theories are accepted, it's going to have an enormous effect on the world of technology. If the making available idea is accepted, I think the internet gets shut down because the whole internet is making things available. If I say here's an article in the Wall Street Journal, and I quote a paragraph from it, and then put a link to it, and you go there and you say, well, this is a great article. I'm going to print out 25 copies and sell them on the street corner. Well, so you violated the copyright, and I'm liable for making it available. Did I ever say to you, you should go print copies and sell them on the street corner? But that's the kind of craziness that such a principle could lead to. And then the secondary liability, if you're liable for someone else's infringement, I mean, that could have an enormous effect. Number one, it could shut down the internet because you have all these companies, the ISPs and stuff like that. What if they're liable for the copyright infringement by another person? It could make it so that the people who own computers, like parents, might not allow their children to have access to the computers. It could, in its own way, it could in its own way shut down the internet. Now, lastly, I just want to say briefly, what can the tech community do? You know, I have no training in technology. In my office in 1991, up to 1991, I had never even used a computer in my life. And I was the last person in the suite to even go near a computer. And only because my secretary moved to Florida I had to get access to my documents that I timidly ventured into WordPerfect. And of course, the rest is history. It was a lot of fun, but I mean, I went to Bronx High School of Science and I had a pocket protector. But beyond those two things, I have no technology credentials. So we need help.
That's enough.
We need help. And let me tell you, this economic imbalance permeates everything. Now, what makes me the leading technology lawyer in the RIAA cases? Well, here it is. In 40,000 cases, do you know how many times a defendant has taken the deposition of the expert witness, the RIAA's expert witness, who spouts off with lies and baloney in these reform reports that he prints out, and based on nothingness? How many times has he been cross-examined at a deposition? Once. In 40,000 cases. Once. How many times has anyone taken the deposition of the investigator, Media Century? Zero. I was trying to get the deposition of Media Century. I had noticed the deposition. I had requested the backup data and documents which we would need in order to determine the veracity, in order to be able to properly turn it over to our expert and see what